Okay, good morning. I've heard it's an early hour for some of you. I apologize. Welcome again for the last day of our Conference of the Future. We have our panel this morning on global issues and lay participation in legal decision making. And to start us off, we have Valerie.
Thank you, Margaret. I'm just delighted to be part of this conference, and I want to thank you, like so many of the rest of the participants have, for bringing us all together in this beautiful environment to do some things we probably should have been doing for a long time, talking about what the important questions and issues are for our field. So great big thanks to you, and also to John Jay and to NSF for helping support this collaborative effort. I want to talk today about global juries and what kinds of research questions emerge from considering lay participation in multiple countries. My academic interest in this topic stems from the mid-1990s when I went to another fantastic conference. This one was organized by law professor Stephen Feynman, and it took place in Italy, and included people from many different countries. There were some researchers, a handful of researchers, including some of the people in this room, but there were also judges and lawyers and policymakers from a huge range of countries that employed lay participation in some form or another. And what I learned then and have been continuing to learn about is the near ubiquity of lay participation in legal systems around the globe. A number of countries use the form we're most familiar with, the form of juries, where a group of citizens is drawn together and decides a case independently. And the US joins a number of other countries, including Russia, Great Britain, Canada, New Zealand, Australia, other European countries, and some nations in some of the other continents. In addition, a topic we'll hear much more about when Sonia presents her work on mixed courts or mixed tribunals. Some people employ citizens as part of mixed decision-making bodies where lay judges are brought from the community. Some picked, they are picked in diverse ways. Some are chosen like our jurors are chosen, but others elected or chosen by other kinds of methods to serve for longer terms, and they decide cases together with professional judges. And we'll hear from Hiroshi Fukurai about this method as it has been adopted in Japan a little later on in our panel. So the ubiquity I want to illustrate just a little bit more vividly. This is a great map that comes from an article by Jackson and Kovera showing the legal systems of the Council of Europe. And it gives you a little bit of a snapshot of lay participation systems. They had a range of ways of identifying different lay participation systems. But what I want to ask you to look at is focusing on the blue in this particular map. And it's really dwarfed by the other countries. The blue represents those countries that do not have, apparently, any form of lay participation. In other words, most countries appear to have some way of incorporating citizen input into the legal system. And, you know, that's really kind of a puzzle. You could understand it in systems that were new or just developing, where there was not adequate professional expertise to decide legal cases, but that's not the case, certainly for most of the members of the Council of Europe countries. It's not the case here in the United States. And yet there appear to be some enduring attractions to using lay citizens as decision makers in one form or another. What's more, there are also some new lay participation systems, and we'll hear a fair amount about that in the panel today from Jay Park and Hiroshi Fukurai in particular. The move toward incorporating jury systems started in the 1990s when both Russia and Spain introduced new jury systems in those countries. And that has continued since the breakup of the USSR. A number of countries that used to be part of the Soviet Union have included juries in their constitutions and are beginning the process of lay participation in one form or another. We'll hear later about both Korea and Japan that have introduced different forms of lay participation. And Taiwan is also considering some form of lay participation system. Casey Wong, who is here with us, is very active in that debate about just exactly what form lay participation should be in their particular country. So why should we care? What does this bring to those of us in this room who have been studying juries in one form or another for a number of years? Well, I think that especially the new systems, but also a kind of comparison across countries that have had long-standing systems, offer a really huge set of fascinating questions about the effects and functioning of lay participation. In a way, the world provides this vast quasi-experimental design for us, and the new systems in particular are really intriguing because we can compare systems, public support for the legal system, other indicators of democracy, and the operation of the legal system, both before and after the introduction of forms of lay participation. So in the new systems, I think, offer this really new and fascinating scientific opportunity. We can study both the immediate effects, but then also the longer-term effects of introducing a lay element into law. Now, as I've looked at lay systems in different countries, one of the things I've seen is the progress is uneven. Some are clearly floundering, and others seem to have, well, they are flourishing. And I think comparing across countries really lets us understand perhaps what kinds of characteristics of a legal system are necessary for the flourishing of lay participation. And they also may give us some insights about how to set up systems of lay participation. You know, what works best? How do you encourage a strong and vibrant role for lay voices in a legal system? So I think empirical research can answer some of those questions. And in particular, I think empirical research can address others. There are lots of assumptions about whether or not, or lots of questions about whether or not lay people who are not, after all, trained in the legal world and who have limited knowledge of legal rules and about their competence and how they can manage under those circumstances. And I think empirical research, certainly in the United States, has reassured some people about the basic competence of jury decision-making, although certainly there are areas in need of continuing reform. But in other countries with no experience at all in lay participation, I think empirical research about the functioning of these systems might be even more important than it is in our country. So that said, there are, I think, really tremendous methodological challenges. And so I'm hoping, as part of our discussion, we'll really talk through what kinds of approaches we might take. I think some of the questions that I'm raising here and that will be raised by the others on the panel are really difficult to study, studying traditional methods of jury research that some of us are, very, very comfortable with. If you were going to look at systematically juries or lay participation forms across different countries, I think you may need to rely on forms of research, like case studies or comparative research, that raise concerns about people trained in experimental methodology who are knowledgeable about issues and questions of investigator bias. And so that's, I think, one of the interesting methodological challenges that we need to confront if we are going to build a successful body of research in this area. I think it really calls for a multi-investigator network. So it's exciting to talk to people in this room who, in fact, might become part at some point or another of a multi-investigator network. I think we need, in a way that we as jury scholars probably have not done so well in the past, some coordinated research strategies. using diverse methodological approaches and asking perhaps the same kinds of questions in different countries and across different research paradigms. So I think these kinds of coordinated efforts are likely to have the biggest scientific payoff. So using similar sorts of questions, studying the same topics, and studying a range of topics that give a full picture about jury research, or sort of the functioning of lay participation in different countries, is, I think, what is needed. So I think it's very important to ask this common set of questions, and I offer just a few here. First, about sort of the context of lay participation across these different systems. I think at the very start we need to characterize the different systems of some are emerge more frequently in civil law countries, some in common law countries. Some offer lay people a great deal of latitude. The typical jury, for example, is sent off by itself to arrive at a decision. Nonetheless, there is a fair amount, even in the US, of judicial control of the jury body. However, compare and contrast that with a system that combines lay citizens and professional judges right in the same room, in the same body, and you can see that the level of autonomy, at least theoretically, is and should be quite different. Systems also seem really to vary in terms of the finality that is accorded, or definitiveness and finality that is accorded to their decision making. And I think that's really important, especially if we think about how to build successful systems where a lay judgment that might be at odds with what the legal rules, sort of what a legal professional might decide, as it sometimes will, is given credence. And the extent to which a jury or the lay participants might be autonomous, the finality of their verdicts, these might depend very much on the purposes of lay participation across the different systems. So I would say we should definitely study support for lay participation among the public, and also legal and political elites. And I think you'll see some of that in the presentations that will follow. I think we should look at the similarities and differences between lay people and professional judges, as there's a long tradition of this in the US, and I'm happy to say that it does appear to be also occurring, some of this work is also occurring in other countries. Finally, I think we need to somehow capture the effects of lay participation on other elements of the system. I want to mention something that I was very privileged to be a part of last year when I was invited to Taiwan to speak to a number of groups about the lessons of American jury research for the Taiwanese debate over lay participation in that country. The judicial group that proposed lay participation, called the Judicial Yuan, had proposed a system that involved lay observers. That is, professional judges would decide their cases, but there would be a number of lay citizens who would sit with them as they heard the evidence in the case and decided the case. Now, these lay observers, they were observers for a reason, because they could observe, they could also talk to the professional judges about their views of the case, but there was no anticipation that they would have a vote in the decision-making, and certainly not binding vote in the decision-making. It's a very distinctive and interesting set of criteria for lay participation. My job was to try to draw on what all of us have learned about juries and lay participation, its strengths, and some of the challenges that it faced. What I suggested to judges, lawyers, professors, and researchers was that initially we needed to, or they needed to, identify what the key research questions and issues were for all of the stakeholders, including not only the Judicial Yuan that proposed this particular system, but for lawyers, for citizen action groups, and for other community members in Taiwan. I also recommended something that I think had been very successful in Japan, which was to introduce a period of mock trial experimentation, which allowed the Japanese, I believe, to really work out some of the kinks in their lay participation system, but also to make both judges and, well, to make judges, lawyers, and citizens familiar with the form. And in a way, it assisted in the training of legal professionals about how to conduct a lay participation system. So I thought that was worthwhile using in Taiwan as well. They had suggested, I think because they were not sure how it was all going to work out, the idea of introducing lay participation in just a couple of jurisdictions. And I thought, oh, wow, that's great, actually, because you can have a lay participation system introduced in a few jurisdictions and then use other jurisdictions in Taiwan as control systems, control jurisdictions, and then compare across those jurisdictions at the end of the study period. So I had a number of specific suggestions, again, drawn from our collective body of work about how to study the impact of lay observers through before and after analyses in a number of using a number of different issues for study. But what I was also struck by is there were lots of questions that really we couldn't answer, that even our collective work so far hasn't really given us lots of the methods and lots of the tools and research insights that we need to give advice and research-based advice, I think, to countries that are considering lay participation. So in closing, I will put in a pitch for a collaborative research network that Sonia and Mary Rose and I are currently organizing It is Lay Participation in Law International Research Network, and it is an open network. And if you are interested in following some of the developments in multiple countries and would like to talk and exchange experiences, research ideas, and thoughts with other people who are interested in this particular area, this would be a place to start. I'll just conclude by saying that I think this kind of work, in addition to opening up a whole range of fascinating questions about something that all of us really, I think, share a very deep interest in, it also foregrounds a question that we haven't talked about very much at all, and that's, what's the purpose of lay participation? What's the purpose of the jury system? It seems to me that's really a fundamental question we need to spend more time thinking about. Thank you.
And our next speaker is Sonia Ipkovich.
Okay, so thank you. The title of my talk is Studying Mixed Tribunals, Theory and Reality. So how will this talk look like? So I'll first briefly talk about mixed tribunals. I'm assuming that most of you are not familiar with the concept, and I'll talk about their legal reality, how it looks, what the legal constraints are. And then I'll tell you more about the theory used to study mixed tribunals, the theory of status characteristics theory. And then I'll tell you what we know from research about mixed tribunals, how well they operate and what the problems are. And then go and advocate that we should study more than one form of lay participation and tell you what we can achieve if we do that. So in a nutshell, mixed tribunals are small groups composed of professional and lay judges who make legal decisions jointly. And here's just an overview of the popular views about mixed tribunals. So in Germany, lay judges are called puppets with strings in the hands of the professional judge. In Russia, they're bodyguards of the professional judge. In China, they're viewed as the ears of the deaf, like furniture decoration. And in Croatia, they're viewed as two heads of cabbage behind which is hidden the professional judge. So the question is, can we learn something from an institution that is being criticized and mocked so heavily? And the answer is yes. I'll tell you more about what the lessons are, and also what we can achieve if we go beyond just studying one form of lay participation. So mixed tribunals are these groups that are heterogeneous groups composed of both professional and lay judges, and the size varies depending on the country. The smallest mixed tribunals would typically have 3 members, one professional judge and 2 lay judges, and the largest ones would have 12 members, 3 professional judges and 9 lay judges. These tribunals are mostly used in civil countries, and it doesn't matter whether they're full-blown democracies, developed democracies like Austria, Germany, or the most recent one that's been added to the list, Japan, whether they are countries in transition like Croatia, the Czech Republic, or South Africa, and sometimes we find them in communist countries like China. So why do people introduce these mixed tribunals? Typically, there is a list of things, and we would see at least one of those reasons listed. They would enhance the legitimacy of the criminal justice system, or promote justice and equity, or they would serve to provide community values and input that into the criminal justice process. Or, interestingly, they would serve as a deterrent safeguard against misconduct by a professional judge. So, as I mentioned before, they typically utilized in civil countries, and these countries use some version of a modified inquisitorial procedure. The important feature here is that judges have an active role and parties have a passive one. So, although there are many different varieties of legal procedures, there are some common themes that seem to emerge across these countries. First of all, admission of guilt does not eliminate the trial. This is just one piece of evidence that's going to be considered as a part of other evidence in the case. Secondly, the defendants do not have the right to choose between the bench trial and a trial by the mixed tribunal. Whether it's going to be a bench trial or a trial by mixed tribunal is determined by the law, depending on the seriousness of the offense or the severity of the penalty. Furthermore, the parties do not have any mechanisms that can use to eliminate some lay judges. There is no voir dire, no peremptory challenge, no challenges for cause. And lastly, mixed tribunals are supposed to serve this active role in the trials. So that means that mixed tribunals are required to seek evidence, examine evidence, and also at the same time control the nature and the objective of the official inquiry. So what can we learn from these groups? The first idea is to use theory when we try to explain the interaction in various groups of lay participants. So when I studied mixed tribunals in Croatia, I used the status characteristics theory developed by Berger and colleagues to explain the interaction in small task-oriented groups. So in the theory, they predicted that group members will develop expectations of other group members based on their status characteristics. And status characteristics are attributes whose culturally specified meaning makes them potentially relevant to the performance of the group's task. And they talk about specific characteristics, those that are directly related to the task, and diffuse characteristics, those that are only directed to the task indirectly. So if you apply that theory to mixed tribunals, you'll see that indeed mixed tribunals are small groups and that their task is legal decision making. So when we talk about specific characteristics, our professional and lay judges would differ depending on whether they have legal knowledge and whether they are experienced in deciding legal cases. Clearly, professional judges would have high states on these two characteristics, and lay judges would have low states. Then we can add diffuse characteristics, characteristics which are only indirectly related to the task. We can talk about education in general, gender, age, ethnicity, or race. So clearly, each individual has more than one diffuse or specific status characteristics. So how do people in these groups combine these elements? How do they form these expectations? They use what the theory says, aggregate performance expectations. In other words, they use all of these characteristics to form expectations. And the idea is that these specific characteristics directly important to the task will carry greater weight in their overall impression than diffuse status characteristics. When you apply this to mixed tribunals, this would mean that legal education, being a specific characteristic, will be more important for someone's status in the group than what their gender is. And based on this, we could expect that professional judges would have higher status in the group because they have more, higher quality of these status characteristics than lay judges. And let me just add here that the procedural law makes professional judges first among equals because of the status it gives the professional judges. They have some additional legal rights and duties as a part of their role. So overall, based on this theory and legal procedure, we would expect the professional judges compared to lay judges would have a higher status, be expected to be more competent, be also evaluated as more competent, be given more opportunities to participate, be evaluated as providing more important contributions, and lastly, be more likely to have disagreements resolved in their favor. So what does research tell us about these status characteristics theory and mixed tribunals? And we can separate the results of research depending on whether we're talking about trial or deliberations. During trials, overall, lay judges are viewed as not being very active. In a number of studies, most of the lay judges do not ask any questions, and very few of them ask any questions or made comments of merit. When we move to the deliberations are heavily dominated by professional judges. Studies suggest that lay judges disagree with professional judges very infrequently, and that the overwhelming majority of decisions are unanimous decisions. For example, in the Swedish study, lay judges outvoted the professional judge in 1 to 3% of the cases, and it's very, very infrequently. And German studies suggest that the chances that the lay judges are going to prevail in their opinion, in other words, they're going to outvote the professional judge, increase only when all of them share this common position. So how can we apply this theory to study juries? First of all, we don't expect that juries on a regular basis would have these specific status characteristics present at all. You would rarely find judges or lawyers acting as jurors. However, then diffuse status characteristics are going to become important. And we can talk about whether all of them are going to be equally important or whether some of them would be more important than others and why. And in a case, for example, of medical malpractice, we can talk about whether someone who has a medical education, a nurse, whether that person would actually be more influential in the jury group than somebody who doesn't have such knowledge. So then, if we want to summarize what we've learned from the studies of mixed tribunals for the jury, there are, I think, 4 important points we should consider. All countries that use mixed tribunals develop a system of selection of these lay judges and expect that the existing selection process will result in the creation of a pool of lay judges that are representative of the community. In reality, there are serious obstacles to this. First, we know from the studies that the politics plays an important role, and that political supporters are overrepresented and members of the lower classes typically underrepresented in the pool of these lay judges. The law also makes this representation, the idea of representation, impossible when they ask that some lay judges should have specialized knowledge. In juvenile cases or cases involving complex economic cases, they would require judges with specialized knowledge. Clearly, it's impossible then to have a representation of the community. Furthermore, countries would typically introduce a citizenship requirement or requirement that lay judges speak the language fluently, which would automatically eliminate immigrants, particularly legal and illegal immigrants. And lastly, the practice has evolved where courts would need to move on with the cases when lay judges do not come to the court and perform their duties. So they establish a system of reserve lay judges. Lay judges could sit there in the court who are repeat players and listen to each and every and participate in each and every case. Clearly, we do not talk about these guys being representative. Furthermore, the laws typically give each member of the mixed tribunal the vote, and they say that these votes have the same power. In reality, this is not the case for several reasons. First of all, trials are held in professional judges' courtrooms, and lay judges feel as they are guests in these courtrooms. Furthermore, the procedural rules put professional judges in the driver's seat. They control the courtroom, they examine the evidence first, they give other members of the tribunal the right to speak, and they also direct the discussion during the deliberation. And in addition, since this is a some modified version of the inquisitorial procedure, a case file becomes an important object in this whole process. And professional judges routinely read these case files, whereas lay judges are in a position where either the law does not allow them to do so, as is the case in Germany, or as the situation in Croatia, they simply do not have access to the case file because the professional judge has the case file, or they don't have time to read the case file. So studies suggest that fewer than 10% of lay judges have actually even looked at the case file. Then the next idea is the idea that if you give lay judges the right to outvote the professional judges, this would establish them as important players in the courtroom. And indeed, let me just remind you, the procedural rules are such that they put the professional judges as the first among the equals. They have a more active role. And furthermore, in some countries, professional judges are required to summarize the evidence at the beginning of the deliberation. Clearly, we can discuss and study the powers of persuasion in such contexts. So it's not surprising then that the studies suggest that lay judges disagree with the professional judges very infrequently. And Kovera argues that indeed, if there are some disagreeing voices, this will be sorted out before the first vote is being made. And if lay judges disagree with the professional judges, they would rarely outvote the professional judge. And lastly, if you give professional judges the power to make discretionary decisions about lay judges, we will expect that they will result in fair opportunities for lay judges. Research suggests this is really not the case. Overall, professional judges support the idea of lay participation, but are also full of criticism of lay participation. They say that lay judges are viewed as emotional, lacking legal knowledge. Well, we shouldn't be surprised they're lay judges, right? They lack general education, and they're being very easily influenced. So, if professional judges share these negative views, then they will not give lay judges opportunities to participate. They would fail to include them in mixed tribunals, as was the case in South Africa, where lay judges had an option of actually including lay judges in the tribunals. Or, if they have to include them because this is what the law says, then they would tend to rely on the same lay judges who support what the professional judge wants to do. So, what can you do if you go beyond mixed tribunals or just one form of lay participation? First of all, we can look at the map of the world. How does the world look like? Where do lay participants appear? In which of the countries? We simply don't know. And if I ask you what the most frequent form of lay participation is, I'm pretty sure that most of you would say the jury. In reality, most of the countries in the world rely on the civil law tradition, and thus we would expect mixed tribunals to be the most frequent form. But in reality, we simply don't know the answer. So that would be one thing that we can study. Furthermore, we can compare the same form across different countries and see what the key features of this particular form are. We can talk about differences or similarities of the same form, or we can compare different forms of lay participation in the same country. How would a justice of the peace and the jury in the United States look like? What are the similarities in these two institutions? So these are simple descriptive questions that we can explore, but we can move into more complex ones. For example, which forms of lay participation are more appropriate to achieve particular goals you would like to achieve? If a particular country wants to emphasize legitimacy of the lay participation, which form of lay participation would be best suited to do so? Or if a new country wants to introduce a particular form of lay participation, we can provide knowledge about what has worked or what hasn't worked in other countries that has been utilized in this form. Furthermore, we can talk about what political, social, economic, and legal factors are associated with successful lay participation. And lastly, we can study the relationship between lay participation and democratization. And for this, we can really look at this particular relationship in two different ways. First, we can study how lay participation is a way to enhance democracy. So we can ask questions such as, does serving on a jury increase our confidence in the government? Does serving on the jury increase the likelihood that we'll participate in other civil duties? Or are jurors more likely to obey the laws? We can also ask and look at this relationship from the other side and say, how is the level of democratization influencing the particular form of lay participation? Are democracies more likely to use lay participation? Or what forms of lay participation are more suitable for true democracies? Or how is the relation between the legal tradition or religion and a particular form of lay participation? So clearly, these are very ambitious ideas and they're burdened with serious challenges or problems in conducting comparative research, starting from heterogeneity of political, legal, and cultural environments, going all the way to the simple ones such as finance or the high costs of doing such projects. So since I have such an ambitious research agenda that imposed on you, I thought that I would end the talk with a lighter note. Okay. Thanks.
And our next speaker is Kovera.
My name is Kovera, and if you look at it, this is the logo for East Santa Cruz. That's the bottom of the slide. If you go to words, because we have like 2,500 acres of campus, and if you go to the words after the rain, you see slug to the size of like 45 centimeters, and it's kind of surprising. And we take the mascot of the university. Anyway,
We have rats.
it is to know.
We have rats. We'll match them up
Okay. Anyway, I'm very privileged to be here, Cooney, and for the past 2 years I edited and helped co-edit, with the help of Valerie, 3 special issues of journals, and 2 of them are law journals, and one is international law, crime, and justice. And then I have the privilege of going through all the papers actually being submitted for the publications, and I've seen the names of the scholars in this room. Reed, Steve, Margaret, Ted, Edie, and also law societies, and Neil, and Sherry. I didn't have a chance to say hello, sorry. But many others, and so and also I'm very privileged to see the new scholars who are also initiating their own research in Zurich. And as for me, I've been studying. I'm originally from Japan. I came here like 30 years ago, and since then I've been studying American juries. But from 1995, I started to see and also participate in the jury grassroots organization in Japan. And successfully, we were able to send one of the key grassroots organizers into the task force that actually had the privilege of drafting the bill for one of the, actually 2 lay participation systems that were being implemented in 2009. So I started to see the more comparative research, and that's one of the ways in which I tried to make some suggestions about possible research that not only American scholars can participate, as well as international scholars can also participate, as Valerie mentioned just a little bit. And so let me start with the system of Japanese lay education system. And despite the fact, as I said, there are 2 systems being introduced in 2009. Japan had a history of lay participation. First, lay participation system was introduced 1928. 1928. And there was a 12 jury, member jury, just like the ones that we have in a petty jury in the United States and Canada. But it was suspended by the military. I hope I didn't waste about 5 minutes. Okay, thank you. So anyway, it was suspended in 1943. And after World War II, Allied forces actually forced Japan to adapt the American-style jury system, but Japanese refused. So, but nonetheless, Prosecution Review Commission, which was kind of modified version of American grand jury, was being adopted in Japan. Now, I will tell you more about it. And the purpose is to weaken the Japanese prosecutors' authority, because the Japanese prosecutors often tortured and interrogated illegally. And, so that was the purpose of the introduction of this PRC, Prosecution Review Commission. And again, 2009, Japanese government decided to introduce sideline system, that's a mixed tribunal system, using the term of Sanya, and also Prosecution Review Commission with a new provision in it. So let me talk about the first of the 2 types of lay participation systems introduced. The sideline system, or sideline civil, which I call the quasi-jury system, composed of 3 professional judges as well as 6 lay judges. They determine outcome of the trial, including sentence. And as of March 2012, more than 20,000 Japanese participated. And Japanese government had extensive study on those people who actually participated, and found 96% of those jury participants expressed their experience as being very positive or very good. And in terms of social class compositions, about 1 out of 10 are either homemakers, that means housewives or house husbands. But unfortunately, there is no statistics on race and ethnicity, despite the fact that Japanese is a multi-diverse society. As you know, that Okinawa, it's one of the large ethnic groups. Okinawa used to be an independent kingdom until it was annexed in 1879, as well as a large group of Burakumi, about 2 million, some people estimate to 10 million minorities living. In addition to Ainu people, which Japanese government declared Japan is not non-racial society in 2008 by designating it as indigenous Japanese ethnic group. So this is the second system, Prosecution Review Commission. It's new. And the function is very unique. It reviews the cases that prosecutors failed to indict or failed to prosecute. This is kind of unique. It's a kind of inverted systems of American grand jury system. And the commission composed of 11 citizens, and the term is 6 months. Unlike here in the United States, it's about a year, like in the state of California. And they are chosen randomly, and they have 3 decisions to make. And they have 3 options. First one is no indictment is proper. That means prosecutors did the right job, so no indictment was actually a proper decision for the given case. And second is no indictment is proper. That's prosecution maybe reconsider their decision. Third one is simply saying prosecutors made a mistake. They should have actually indicted the criminal suspect. And the Prosecution Review Commission determined twice, okay, especially the second one, that the indictment is proper for a given case, then that becomes legally binding. And that was actually initiate the forceful prosecution of the previously non-indicted criminal suspects. Unfortunately, the government doesn't do any survey on this particular system, that's why I was very interested in this system. Now, in terms of the research between ignited after the introduction of cyber system, there have been studies on the impact of lay participation on the procuracy, attorney, judiciary, and police, and also research done in crime and criminal justice process, sex crimes, and Japan uses victim participation system, and also how the pre-trial conference procedure, as well as the introduction of discovery. Japan did not have a discovery. Now it has a quasi-discovery procedure being introduced, how that actually affected disposition in criminal case. And also, many scholars are interested in how jurors deliberate dynamics. Some people actually use simulation techniques. Some of you initiated in the United States. And also jury selection, deselection, like Margaret has been doing. And also some scholars are also interested in the societal impact of lay participation. And I particularly was very interested in the adjudication of American and Japanese armed force personnel, especially in the island of Okinawa, because Okinawa, again, was the independent nation until Japan annexed it. And it was colonized by Japan first, then it was reoccupied by the US military force after the 1945, the Battle of Okinawa. And there are about a little less than 250,000 accidents and crimes being committed, and also more than 1,000 people being killed by US personnel. And so, unfortunately, the Okinawans did not have any opportunity to adjudicate the case over the crimes being committed by either Japanese or American military personnel. This late participation system actually gave the opportunity for Okinawans to actually be in position to make a decision on the crimes committed by their occupiers. And some scholars are interested in the possible application, extending it from the criminal case into a civil and administrative cases. And especially it's very important given that there is going to be a tremendous civil cases, civil litigation filed by the Japanese radiation victims in the future. So I think lay participation system is going to be very important in those cases. Now this is the second system, and then the kinds of research being done on the Japanese grand jury. Now think about it. 99.9% of indicted cases by prosecution result in conviction. That means you need a court. Decision by the prosecutors is sufficient, doesn't it? But if you actually look at it from the criminal suspect's point of view, people that the prosecutions decided not to indict, they're actually being protected for prosecution. Okay? So the abuse of power by the prosecution in Japan rests upon their decision not to prosecute the criminal suspects. That's exactly what this prosecution review commission does. Evaluates the propriety of non-prosecution decisions by the Japanese prosecution. And that review initiates upon the request by the citizens to review the non-indictment decision. And because of the legally binding authority of this Japanese grand jury, there are a group of untouchables now being exposed to the Japanese possible prosecution. The J.R. West is one of the largest corporations in Japan. The 3 past presidents are being indicted and are being prosecuted as we speak for the trial derailment accident that killed more than 100 passengers. Ichiro Ozawa, which I dubbed him as the Dick Cheney of the United States, he was actually indicted and possibly prosecuted. He was acquitted, but prosecution appealed acquitted. That's possible. So he's still being adjudicated. And American military personnel been shielded by the status of forces agreement. But they are now being exposed for the prosecution. And there are a couple of cases that American soldiers being adjudicated and sent to prison. So the PLC is very important in terms of oversight of the government and large corporations, their egregious behaviors, and as well as occupying force. Not only American forces, as well as Japanese forces in the case of Okinawa. Now, this is my suggestion for comparative research. And it's often neglected areas in the United States, because I know it, because I see very few scholars actually focus on, not on the petty jury, but grand jury. And now, grand jury exists in the United States at both state and federal level, right? Federal level, we only have criminal federal grand jury. We don't have a civil. And but in the state of California, we have a civil grand jury that exists in every county. And the 19 through 23 grand juries. In the county of Santa Cruz, we have 21 grand juries, and they serve for a year. And what they do is here, oversight of local government. They check malfeasance, misfeasance, or non-feasance against public officers. And they investigate local government, local jails. If they're imprisoned, they check those facilities. And they also examine citizen complaints. And they issue a report. And one of the cities in Santa Cruz, Pajaro Valley, was accused of misappropriating some funding, and the city officials are fighting against the grand jury report as we speak. And that's the function. And that's exactly what the Prosecution Review Commission does. It reviews the power of the government in terms of their decision to prosecute. And there are 165 commissions all over Japan. So, why don't we look at the socio-political impact of the jury and their power to act as an oversight of the government? And why don't we start looking at the decision-making of the civil grand juries? How they actually evaluate the government agencies and their officials. It's applied in the real cases. And what's the deliberative dynamics on very controversial political issues? People's willingness to participate, whether they really want to participate or not. Because it's for a year. It's not just a case like this. Is there public support? And what's the power of annual reporting of their findings? That's what the grand jury does. And is there any deterrent effect against corporate relations or governmental misfeasance and so on? And another research is there's no civil grand jury system outside of California. And why don't we actually look at possible adoptions of civil function of grand jury, say in the state of California, here in New York, because I think last year there was a report done by the investigative reporter that exposing the hundreds of millions of dollars being appropriated for allegedly creating the computerized accounting system that was going on, all scammed, right? Do you remember that? Here in New York. And it was done by investigative journalists. But if you have a civil grand jury here, New York, it's done by the civil grand juries, just like it's done in the state of California. And also, what would be the possibility of having civil, federal grand jury? And there are 94 federal court jurisdictions. So each jurisdiction, why not have a civil function of the grand jury? Because we already have a criminal grand jury system. Why not apply that to the civil grand jury? And each jurisdiction will review civil complaints as well as review the action of FBI, whether they're actually doing surveillance of the citizens or whether federal prisons are being run properly and any other federal offices that fall within that federal jurisdiction. So anyway, so that's the kind of suggestions. That's what I'm trying to head my research into. I'm also doing the petty jury comparisons, but at the same time, grand jury research. That's the areas I think it's been neglected by the jury researchers in the United States, especially its political function. And that's something I try to look at. And again, layer adjudication in petty grand juries, differential functions, utilities, both in Japan and the United States. And there's a possibility for comparative research. And we need to create really civic oversight around our government. We have National Defense Authority Act, and you're a citizen or anywhere in the world can be detained without cause, indefinitely. We have that law, and also the NSA now has 20 trillion pieces of information of all of the emails. That's the whistleblower that exposed a couple of years ago. And people who have smartphones, their content, and also for your locations in the past and present. Now it's part of the governmental data. It's not up to the government, to have those kind of information. But nonetheless, we need to have a leash on the government. That's how I actually direct my research into the areas.
Now we have Jay Park.
Hi, my name is Jay Park. I'm very happy to be here to present Korean jury system. As many of you already know, the South Korea has instituted jury system in January 2008. And it took about 7 years of extensive discussion, debate, and also legislative effort to make it happen. But this is really a remarkable event in South Korea because there has been no history of lay participation in South Korea at all. And many political benefits were anticipated, and it has been severely challenged by the opponents as well. But it has been more than 4 years since it has been implemented, and it seems like it's settling in now. But there are a lot of trial errors as well. During the first year, some Koreans, they got a summon letter from the court to serve as jurors, and they thought they did something wrong. They had to call up the court and make sure that they're not really doing something wrong. Before I move on, let me just talk a little bit about the characteristics of Korean jury system, because it's mostly modeled from the American jury system, but at the same time it has some unique features. For example, it is held only for serious criminal trials. There's no civil cases tried by jury. And the defendant must express his or her intent to be tried by jury. And each jury consists of 5, 7, or 9 jurors in proportion of the seriousness of the criminal charges. And the unanimous verdict is expected, but it's not required. So majority vote is acceptable after if the unanimity is not reached. And most importantly, the jury verdict is only advisory at the moment. It has no binding effect, which means that after juries return the verdicts, the judges have to make their own independent verdicts. And this is one of the hottest topic now. And also the jurors can make sentence recommendations. But it should be noted that it still is tentative in nature, which means that at the end of 5th year, which is this year, an official evaluation will be conducted, and the government will make a decision about the future of the Korean jury system. So the purpose of this presentation is to report and review the first 4 years of Korean jury system, and also discuss the major issues derived from implementing the jury system. So I want to raise about 4 questions. The first question is, because it's the first time in Korea where there is no history of lay participation, so how's it going? That's my first question. So I want to give you some descriptive characteristics. The second question is about the jury competence. And this is very important not only for the researchers, but also for the law professionals and the government. They want to make sure that the jurors can make valid and accurate judgment about the case. And the next question is about the perception by the Korean citizens. So I'm going to report one nationwide survey study. The last one is about the challenges and possible solutions about the Korean jury system. So let me start from, the sources are coming from the governmental statistics, archival materials, and some empirical studies. I was lucky enough to have some connections in my college in Korea, so I'm constantly getting some information and reports from South Korea. First, for the first 4 years, there is a total of 574 cases tried by jury. And this number of cases was counted by the number of defendants. In some cases, it's counted a little differently based on the number of criminal charges. But this number is coming from 1,490 cases where the defendant requested the jury trials, but only about 38.5% were accepted and tried by jury. The other cases, they're either withdrawn by the defendants or rejected by the judges. And the judges find it inappropriate, then they have the sole discretion of rejecting the cases. The reasons include things like if there's additional charges expected, or if the case is too easy or too complicated, or in some cases they just have to reject the cases, including sexual offense cases. Maybe this is cultural issues, but the victims or sometimes even the witnesses have a strong objection to be tried by jury, so they have to be rejected. Okay, as you can see in this table, starting from 2008, the number has been increasing every year, and so is the acceptance rate. So during the first year, it's only 27.5%. However, at the end of 2010, there's some internal regulations in the Supreme Court in South Korea. So, well, they try to reduce the number of rejections. So the acceptance rate has gone up in 2011. So more than half the cases are now being tried by jury. The types of criminal charges are spread across many different types of crimes. The number of jurors, over 90% of the cases were tried by either 7 or 9-person juries. And maybe this is quite surprising to you, but over 90% of the cases were tried, the trial was completed in one day. The foremost reason is that the jurors, they didn't want to have another day skipping their work. So they wanted to get this done within one day, no matter how late they said. So it's very common that the jury trial is going after 9, 10 p.m. or even after midnight. The conviction rates, the jury trials 91.6%, but compared with other criminal trials is 96.7%. If you compare the acquittal rate, it's more than twice as many. It's not that high as in Japan at 99.9%. And the jury trials, as you can expect, is a little lower than the other criminal trials. What's more important here is the appealing rate. by the prosecutions. In other criminal trials, prosecutions appealed for like 23% of the time. But when it's jury trials, about half the cases were appealed. And this is a quite serious challenge for the success of these jury trials. I'm going to talk about that later. Now let's move on to the next topic, judge-jury agreement. My colleagues and I have conducted a research recently, and this is coming out next year from JALS. And this study is examining the agreements and disagreement rates between judges and juries, and it follows the well-known studies about the judge-jury agreements. Study back in like 1960s, and paradigmized the well-known classic Chicago jury project, and also the Eisenberg study using the NCSC data and pure panel study. We're all following that kind of tradition. And we used the first 3 years of cases, starting from January 2008 through October 2010. The number of cases as counted by the number of defendants was 274, but some defendants were charged with multiple crimes, so and we counted them separately. But the actual number of cases to be analyzed was 323. And we had many various source data, and we were able to collect many variables. But I want to remind you that the jury verdicts is only advisory. There's no binding effect. So the judges have to make their own verdicts after the juries return their verdicts. So it's supposed to be independent. So this paper summarizes the result. As you can see here, both judges and juries acquitted about 21%, and they convicted 70%. So combining these two together, that's about 91% of agreement rate, which is much higher than the other previous studies, which showed that 70–80% of the cases. When they disagreed, not surprisingly, juries were more lenient toward the defendants. And we did some further statistical analysis, and disagreement rates were way over the rate that can happen by chance. And the agreement rate was further analyzed by evidentiary strength and evidentiary complexity. The 2 independent raters, they're all legal professionals. They rated the strength of evidence for conviction, because that was only available data. And they classified all the cases into 5 levels of the evidentiary strength. And as you can see, throughout all 5 cases, the agreement rates were pretty high, but it's getting a little getting higher as the evidentiary strength is becoming stronger. Perhaps when the strength of evidence is getting stronger, there's not much room for other factors to come in, so the agreement rates were a little higher. We also analyzed by evidentiary complexity, and across all 5 levels, as you can see, the agreement rates were pretty high. One exception is when the complexity level was medium. We have no meaningful reason why, I mean, it has to be low, but except for this one, across all the levels, the agreements were quite high, which means that the evidentiary complexity didn't play a role for this high level of agreements. Now the question here is why the agreement rates are so high. There are a couple of possibilities. The first possibility is that maybe the independence between the verdicts is violated. So although the judges are supposed to make the verdicts, but they let know what the juries made. So somehow the independence was violated. Another reason might be that some cases were rejected by the judges. So if it's like too easy or too complicated, it was rejected. Maybe that was, increasing the agreement's rate. But I mean, they are all like speculations. More research is needed to clarify the reasons. Now, let me move on to the next one. And recently, actually last year, There's a research report from the government agencies, Korean Institute of Criminology, and they did a large-scale national survey, including all the participants of jury trials, such as the former jurors, the defendants who had the jury trials, the general citizens, and the legal professionals. And they're asking about their attitudes and opinions and their perceptions about the jury trials in general. And they used the 4-point scale, but somehow they used it in inconsistent way. So I will explain what that happened, how to interpret the data. The first few questions about the effects of jury trials as perceived by the Koreans. Because they used the 4-point scale, the last 2 points, the agree and strongly agree, were combined to indicate the positive responses. As you can see, all the participants, former jurors and the citizens, even the defendants, seem to be quite positive about the effects of jury trials, which includes the fairness of trials, transparency of trial processes, and protecting human rights of defendants. The next question is about the major concerns with jury verdicts. And many people raise doubts about the accuracy of the verdicts. And they thought that maybe it is affected by social relations, if they went to the same schools or they're coming from the same hometown, maybe it's affected, the jury verdicts may be affected. But interestingly, although the general citizens showed higher level of concerns, but people who actually served as jurors had very low concerns about it. So they somehow knew that they were not affected much by these concerns. They're also asked about the jury verdicts, especially the binding effects. This is a bit disappointing because most Korean citizens, the former jurors, including general citizens, they expressed that jury verdicts should be only advisory as it is now. I mean, they don't seem to be quite confident about their own legal decisions that they're making at this point. And this is another a bit disappointing data. About the intention to serve as jurors, the former jurors had a higher level of intention to participate again. But the general citizens were less motivated, so more than half the people showed little intention or no intention to participate. And the reason being that they don't want, they think this is their a duty as a citizen, and also they have to away from their work. That was the biggest concerns by them. What about the overall the evaluation of the future of the jury trials? Then people showed quite positive responses by the former jurors and the general citizens. There's some data by the legal professionals. The same questions, and well, here they use the 4-point scale in a different way. So the 1 being most positive and 4 being most negative, so about the 2.5, anything that's lower than 2.5 means more positive responses. And as you can see, the judges and lawyers were showing mostly positive responses about the jury trials and also the effects of jury trials. But the prosecutors were the only group which showed more negative views about the jury trials. Pretty much the same pattern here about the 4 years of jury trials. When it comes to incorporating lay citizens as a fact finders, the first one, the judges and the lawyers were more positive about having the lay citizens as the fact finders, but prosecutors were more negative. But when the question is about the granting jury verdicts binding effects, then both judges and the prosecutors are more negative about giving the binding effects to the jury verdicts. So this seems to be quite problematic. So overall evaluations, this jury system served the purposes. It seems like all the participants seem to think in a positive way. Can jurors make valid and accurate legal decisions? The empirical study shows that yes. But it comes with a number of problems and suggestions. Let me just focus on the first few items and then I can conclude my talk. The jury verdicts, it has no binding effect, and this is the foremost topic right now. Then why they didn't give any binding effects at the beginning? because it's supposed to be tentative for the first 5 years. And the Korean government was not sure about the validity of the jury verdicts. So they thought maybe it's better to be just advisory, and a decision will be made later. And some people even raised the issues about unconstitutionality, because according to Korean Constitution, it states all citizens have the right to a trial by a judge as stipulated by the Constitution and the law. And there are some issues about the interpretation of this judge in the Constitution. Is this really a literal meaning, or is it somebody who's appointed by the law? Then it could be jury. But the people didn't want to get stuck in this debate about unconstitutionality, so they just moved on. It's better, it's more practical solution to giving no binding effect. But it's quite clear that the jury verdict should have the binding effect, and it's really necessary for the actual lay participation in clinical trials, and the jurors will take this service more seriously. And in recent Korean Supreme Court cases are quite noteworthy because it gives a lot more weight on the jury trials. It offered the restrictions on the appellate court's authority to reverse. So under some circumstances, the appellate court cannot reverse decisions unless there's a clear and convincing new evidence. The conditions include a criminal case is tried by a jury. The jury returns a unanimous verdict that the defendant is not guilty, and the bench adopts the verdict and rules accordingly. If all these conditions are met, the appellate courts cannot simply reverse the decisions. Let me just skip to all these issues about the rejection rates and high rates of appeal. So concluding my talk, well, the Korean jury system has a lot of significance in many ways, in research and also in practice. It allows the researchers to examine how the social and cultural variables moderate the findings that we have known. And also this is making a new case where we can actually study more meaningfully the lay participation in the world. So again, the future of the Korean jury system is determined later this year, and a more official, official decisions will be made by the Korean government at the end of the year. And what I hear from my colleagues in Korea is that, it's more positive, and it is more likely that Korean jury system will survive, and but some decisions have yet to be made about the binding effects issues. Thank you.
And our first discussant is Steve Kovera.
Because I, at the same time, was carrying around in my pocket a figure which the table I should be
No, I'm sorry, can you please use the microphone? I don't get any audio on my camera without that.
I'll endeavor to do that. I've been carrying around in my pocket on my thumb drive a table based on my extraction from, I got farther than Christina in the book. I went to the index and extracted some research from the index. I'll show you here. Like Wordle, Steeple, the software system that I use, the wetware system that I use, can vary the sizes of the entries and also make use of color. I don't think there's anything meaningful about coloring, is that right? No. Okay, so I pumped up here in size the entries from the index to reflect the number of times, number of pages in a sense, devoted to these topics. And you can see some of the big ones. Steve will also classify these into topic areas, general headers. We can debate about that. One can also add color, and you could do this the way rate of weather. Right? So, and this could be the effect sizes ranging from small from the most purple to the largest green. The problem is this is all bullshit Brian hasn't finished the meta-analysis, but when he does, we'll get back to something else. Now, why do this? One of the reasons I did this was, A, I don't have any substantive knowledge to add to the presentations that we've heard today about the various international jury systems. But I have thought about the relationship between what most of us, and probably half of us in here, especially if we include the graduate students, are experimental, mostly social psychologists who have generated this body of research. And there's little in the way of comparative. That last column there, system with legitimacy, that I put that in a small spot, because the word legitimacy does not appear in the index. I don't know if it even appears in the text at all. Well, I should say, I also regard these. This is, I thought of this as sort of a horizontal brain scheme on Dennis's brain. And this sort of vertical brain scan. I added in a few topics. One of the advantages of the Stevel system is that you can do online updating. So I actually, around 7 o'clock last night, went in and added a few topics down here. So you'll see, amongst the additions, stay near the microphone, I picked up Ted's reference here. Now, I think that's a friendly euphemistic acronym for something like, this is reference to judges, something like intelligent, decisive, independent, and so on. That may be true. And here's Reed's reptilianism. There were, well, at least those two I dropped in. So this, in a sense, reflects the lens, the research lens, through which I see the jury world, and through which I think many of us see the jury world. And we could spend some time talking about why this range of topics constitutes the body of research that makes up Dennis's book. We talk about what sort of questions have been addressed in this body of research. We talk about the research methods that have been deployed to generate this body of research. And once we were done with that, I think one of the things that we would conclude is that there's a rather stark disjuncture between this body of research and the body of questions that are posed by the comparative jury research possibilities that are presented to us as a result of developments around the world, an increased use of lay participation in juries. Now, if you listen carefully to the presentations this morning, they really concentrated on a lot of what I would term macro questions about the jury. And what I mean by that, somebody, I think Hiroshi was using the term socio-political questions. They tend to be socio-political questions, macro aspects of jury systems, whereas these tend to be, for the most part, maybe even entirely, sort of micro questions about the jury, the functioning of the jury, looking at aspects of jury performance, looking at threats to the reliability and predictability of jury verdicts, and they flow from, in a sense, the application of our experimental research methods to this group decision-making body. Now, I've had at least one graduate student, named Kim, who has been referred to, or some of the more recent research referred to, who worked with me here at John Jay and wanted to do some comparative jury research before going back to Korea. And that's been a topic of some interest to me. I have a 15-plus year argument going with Peter Van Koppen about the question that's really posed by Ted's idiot reference. I agree with you that the idiots are no more effective in making decisions than the jurors are. Peter has long been arguing that professional judges are better at this. It's ultimately an empirical question. We've not gotten around to addressing the question empirically, although there was a reference in one of the presentations to our book on adversarial versus inquisitorial systems, which was a product of a debate that we staged at an international psych law conference 8 or 10 years ago, with a set of, it's an edited volume of people coming at that issue from different perspectives. In maintaining that argument with Peter, it has always been my view that there is a body of research that can be generated through the application of the kinds of techniques that are represented in this body of research, particularly the experimental methods, and a body of research that can be generated in a sort of comparative framework, looking at aspects of performance, threats to performance, the ability of jurors to make decisions that are in conformity with the general expectations, and also look at threats to reliable decision-making by juries. And that's what Min attempted to do in her dissertation. Now, one of the things that quickly became apparent to me, to both of us, as we devised a research strategy, and what she was interested in was looking at evaluations of confession evidence by lay and professional decision makers in the U.S., in Korea, and we also wanted to do Dutch decision makers. Though it's a practical matter that just proved too difficult. I wanted to get her out of the PhD program before she reached retirement age. But there are lots of problems in doing that kind of research. I go back to Dan Krause's comments about jurisdictional differences as a threat to the conclusions that are reached. And he's thinking about jurisdictions within the United States, I think, when he's saying that. Imagine the jurisdictional threats, which are represented by the differences in procedure and materials that are presented to lay decision makers and so on. Min managed the study, but over a lot of hurdles in terms of how to formulate and execute such a study. Ultimately, we settled on using a videotape of an American hearing in which she wrote Korean subtitles, so everybody saw the same confession and trial presentation, and everybody essentially was required to answer the same questions. But in neither instance, that is neither with respect to the American participants nor with respect to the Korean participants, were they necessarily seeing something that would satisfy the marketing guards that I talked about yesterday with regard to this research. But it's a sort of first step in the direction of thinking about a way of bringing our experimental orientation, our experimental methods, and our experimentally confined, I'd say, questions to a comparative context. Beyond this kind of comparative study, making use of experimental methods, I frankly see myself as out of the picture. I am not equipped to do the sort of comparative research that would address the socio-political questions that are raised in today's presentations. That's beyond my methodological set of skills. It's also, in a sense, beyond my methodological set of interests that I don't really want to learn how to deal authoritatively with the language problems, with the stimulus material problems in that sort of context. And that prompts me to think that if we're going to be successful in marrying the sort of existing body of experimental research topics and methods to a comparative setting, we're probably going to have to find ways to train a different kind of researcher than we're currently training, say in our program. And I don't know exactly how that is going to occur. I'm not sure where those researchers reside. And I'm not sure that if they exist, they're going to find this array of questions interesting to address using their comparative techniques. I think they may be drawn more to the socio-political issues that have been the subject matter of this morning's presentation. So I guess mine's sort of a, not sour, but glum perspective on the future of comparative research, addressing the sorts of questions and using methods that I have traditionally seen. Just want to check my notes, see if I've covered all the topics that I'm looking at. There's another reason, actually, that has not come out here that I'm a little glum about this. I noticed in the filings in the Perry cases, an eyewitness case decided by the Supreme Court this past year, in those filing materials, there was an allusion to the rate at which trials are taking place in the United States. And the numbers actually surprised me. They were 97% plea bargaining rate in federal courts, 94% plea bargaining rate in state courts. I actually went and looked at the numbers, although I didn't dig in to see exactly what the denominators for those numbers are. But 94 and 97%. The jury is really kind of disappearing out of the American system. Now, I think that raises a whole host of other interesting socio-political issues, which I'm not equipped to address. But it also signals to me that those of us who've been interested in the jury have been looking at a vanishing target. It prompts me to think I should be shifting my attention more thoroughly to plea bargaining as it goes on in the United States, because that is really where the decision-making actually resides. And I would agree with Hiroshi that attention to grand jury proceedings is also an important place to devote our attention, although that's very difficult in the American system because it's much more secretive enterprise than is true with regard to jury decision, juries and jury trials. Even the plea bargaining process is not very open, although I think it is more accessible because defense attorneys are actively participating in it, and I think they are interested in knowing such things as whether they're achieving justice and providing satisfaction to their clients. So when I think about plea bargaining research, I think about roping Larry Hoyer back in on collaboration because he does a lot of work on procedural justice issues. I see I'm out of time and I'm prepared to turn things over to you.
Our last discussant is Lovely Martin.
One of the things I've actually enjoyed myself very much today, and I was sort of saving my my comments to come in as the cranky old, and he's kind of beat me to it. I mean, I'm really sort of serious about that. That is that I too have a kind of view of, I'm not sure how much our experimental work, although I've certainly found myself in the last few years kind of more interested in systematic qualitative research, and some of my research, in fact a very large percentage of it in the last year, has been focusing more toward the interaction of police and prosecutors in deciding to prosecute, so getting into prosecutorial discretion, and that's where I'm shifting my focus away from the jury per se. But one of the things I think that would draw to people's attention is back in, when was it, 1974, when I went to Yale Law School, I became aware of Miriam Gamishka's The Faces of Justice, where he compared the adversarial versus the inquisitorial systems. Herbert Packer's work on crime control and due process, You know, there are a series of things like that, and I think that the point that is being made here is that you really can't understand the jury system or lay participation without having some knowledge of the procedural system of the different countries. And I think it's incredibly important. And what I was originally planning to do, it's still going to constitute it. If you take anything away from my brief comments on this, is go read this book. It's Steve Thayman's World Plea Bargaining. And it is a terrific book. And Maximo Langer's first chapter in the thing is an incredible introduction to the procedures that we have. And somebody, I think, was just making a comment about the plea bargaining and how much it drives. You know, plea bargaining is driven in large part by the cost of jury trials and people trying to avoid it. It turns out that there are quite a few other systems that are now playing with and having some problems. So let me give an example, because at Duke, over the last 2 years, a year and a half actually, I get drawn into this all the time. We had some judges from Moldova who came to learn about the American system, and especially juries. And one of the things that I just was amused about, I started talking about our American jury system, and again, it's a half-hour talk to them with the translators, so you don't get very much done. But I could see their interest was waning pretty quickly in what I had to say about juries. And I said, well, how many have heard about the coffee spill case? Every one of them. And I've given a talk in Australia and New Zealand, and every time I bring it up, they bring us up about the damn coffee spill case, because that has permeated things, even though it's a civil case. Everybody does it. All these judges just went up, you know, so I established rapport with them. But I just recently, at Duke, we had about 10 days ago, a group of jurists from Ukraine. They're developing a jury system, and again, they have an interesting aspect of it. And within the next few days, the reason I was reading this is, and I'm not going to take part in it, but I actually provided the advice to people. A group of judges from Turkey are coming to Duke, and the reason that they are coming to Duke is they're trying to investigate how they can get rid of the backlog of cases through plea bargaining, which their system just does not recognize. So I don't think it's in the works to develop a jury system, but they're actually interested in trying to find out, you know, what is this plea bargaining about? Of course, our system of plea bargaining came from the jury system because of the costs and so forth. So there's a lot to deal with that there. And then the third thing I've got is, I don't know where I've developed this, but somehow I am now supervising 2 SJDs at Duke who are from Taiwan, and I've actually had a couple of LLM students from Taiwan, and I'm going to get corrected on some of my perceptions of this. I'm going to say a few things about Taiwan. But one of the things that I've learned is, from my groups of students, in fact there have been, I think, 6 of them that I've had fairly close contact with over the last couple of years, is Taiwan executed 2 people, 2 separate cases, where shortly after they were executed, it was found that they were not guilty. And that's caused quite a bit of stirring. One of my other LLM students, who's married to my SJD student, but she's back in Taiwan, serving as a defense lawyer, they have just gotten somebody out of the slammer who spent, I think, about 12 years in prison using something she learned in our courses here about expert evidence. And it turns out it was knife marks. And this expert had used, I mean, it was pseudoscience from the beginning. And so she's injected that into the system that had never been challenged before because of the inquisitorial system that is in place there, because nobody questioned it. And one of the things that I've learned, and again, you can correct me on this, but judges and prosecutors are trained together in the Taiwanese system, they live in the same dorms. You talk about ex parte communication. It seems to me that there's a great deal of that. That's something that we just would not accept in this country in the same way. And in fact, I learned from my students that most of them live in the same neighborhood after they get out. So there's a lot of this going on. At least this is what my students have told me. So the reason I'm raising this is I think it is very, very difficult to make these judgments about the system unless you're deeply involved in the culture, speak the language, and understand the procedural system. And once again, I'm going to argue for you strongly to read this book because it is, I haven't finished it yet, but I've been reading it just out of my own interest, and it just really teaches me a great deal. But one of the things, let me just sort of digress, because we all end up treating even our Anglo-American common law system as a similarity. And over the years, I've discovered some very big differences between our American system and the systems of the others. As many of you know, I spent my first 20 years in Canada when I first became interested in this. They don't typically have a voir dire. They have something called a procedure, which is a challenge for cause, which they adopted from England, which means under special circumstances, they can ask 2, 3, 4 questions of the jurors, but typically they take the first 12. There's some peremptory challenges, but other than what we would call a challenge here through voir dire just doesn't exist. Except then Canada has another procedure. In the Northwest Territories and Nunavut, because that section of Canada up there that has the Inuit, Eskimo, if you will, to use the old terminology, now out of favor. The judges on their own in the Northwest Territories decided to implement a procedure because many of the Inuit still do not speak English. At least their main language is Inuit, and there are about 6 different language groups between the Cree and the Inuit and so forth. On their own, it has no parliamentary procedure in the law, but they've actually assigned a Inuit, chosen them for the jury, assigned an interpreter to help them through the English trial, and even put that interpreter in the jury room while the jurors are deliberating. This is an interesting procedure in which comes about. So what I'm suggesting there is you even see within a single country changes and adaptations of the procedural system. The other thing that I've learned, because I've testified about 4 times now via video conference in Australia and New Zealand, is that they have quite a different system. They do not, even though it's on the books, have not for, I don't know, maybe never, done any kind of challenge to the jury. If you take the first 12 people, there are some peremptory challenges. And so in the cases I was involved in involved pretty massive pretrial publicity. And their alternatives are either to just delay the trial, and even the thought of moving it to another jurisdiction just seems to be beyond their scope. And so these are pretty important things, and of course they have some additional problems. In New Zealand, the Maori, the indigenous people, there are some of them, they've never signed the treaty, so in the northern island of New Zealand, they have problems there because they're often not on the jury, and that's something else. So you have the jury system with these kinds of mixed countries. And the reason I bring that up is the judges from Moldova seem to be very hostile to the idea of a jury system because they point out, and I suspect it's true of a number of the other countries in Eastern Europe, they said there's such an ethnic divide in that country that they didn't think the jury system would work. Because, how would you do it? I mean, I guess you would have it subgroups within, maybe like the Inuit, but anyway, they were just not very receptive to this. And again, it's partly a procedural system and the like. But what I'm trying to suggest is that even within our common law countries, and I think you probably all know this, that there are these various problems of adapting it, especially with regard to the system. There are, in fact, in inquisitorial systems, no rules of evidence in the way that we think of the rules of evidence, including excluding prior criminal records. And I sort of wonder about this. I mean, I think Valerie was commenting a little bit about it. Again, I don't know enough about this. I guess I could learn a little bit more. But if I don't speak the language in these countries, I'm just kind of out of luck because I think I would just have real problems with it. So if you're going to do this kind of work, you need to collaborate with somebody. So I think that this whole notion of what do the jurors know, what do they learn from the judges, including prior criminal record. Of course, we have these rules. If you testify, then your prior record can be brought forward only to show whether you're truthful or not. Well, that sort of thing is just absent from inquisitorial systems. So I'm going to keep my remarks short, and I'm going to prove my point, probably, because we have a professor here from Taiwan who knows about the system, and I'll let him actually contradict me, and then I'll sit down and say, I rest my case. Okay? The Taiwanese system, like Japan, like I think Korea as well, is based upon the German Code of Civil Procedure. And it's a code that goes way back. Germany changed it, of course, in 1975. As I understand it, and we had a brief conversation the other day that sort of contradicts what I've learned a little bit, is the Taiwanese system has not changed very much from the old German code. And again, I'm willing to stand corrected on that, okay? And I've already made some comments about this. The other thing is, whenever cases are appealed, it's de novo review of almost everything, even if it gets up to the Supreme Court. And so the point that I'm learning fairly much from this is that it is a difficult job. It's such a fascinating thing to see, to compare these systems, but there are a lot of intricacies that when we talk about lay participation, it is difficult to do. And I just go back to, and I'm going to end my brief comments back to this, because one of the things I started looking at was with the German lay participation and the whole notion of Absprache. An inquisitorial system does not permit plea bargaining per se. But the Germans, to take one example, I just choose the Germans because I once sat through a German rape trial, or most of it, and when I could actually understand and speak a little bit of German, and I had my colleague Winter Bilbao by my side to help interpret for me. But that just was not a notion. So they now have something called an Absprachen, or confession, that plays out. So they sort of have plea bargaining, but they don't. And it's not recognized. And I think it's just very difficult to try to transplant this. And I would say this for Korea and Japan and so forth. All of these things need to be looked at. And I think you probably are looking at them. But I mean, for the rest of us here in the audience, I think you need to be aware of the great difficulties, the complexities. And I think Steve and I probably end up in the same thing. Even though I've been talking that I'm going to help my students and try to work on this, I think I should be doing something else. Kind of shifted my, as I've mentioned several other people, kind of a mid-career change in my instance to try to look at this interface of prosecutors and police and the decisions to charge. So that's kind of where my research is going. But I still can't give up juries. I'm actually currently working on a death penalty case in California with pretrial publicity, and I just keep saying to myself, I got this disease that I don't know how to say no, so I'll still be in juries for a while. So I would like to take a moment. Do you want to contradict me? You're perfectly welcome. Just speak about it if you want to, as part of our discussion.
Actually, I'm not trying to contradict you, but to begin with, allow me to say this is by far the most wonderful conference I've ever been. Not because I can enjoy the luxury of just observing without the obligation to make a presentation. But just I really learned a lot from all of you leading scholars on the topic. And Mary Rose issued an issue of how this kind of jury research have actual impact. And she tried to look at how many articles were cited by the American courts. But I can tell you my experience because like jurisdiction for us, for example, Taiwan, we start from ground zero. We have to make so many policy decisions, fundamental decisions, where the lay judges will deliberate with professional judges. How many lay judges should participate? Should they get a vote to determine the defendant's guilt? Should they have a voice on the sentencing stage? And what I did is just read as much as your research as possible and try to get insights from all the findings, the consistent findings from the body of such a the rich body of your research on this topic, and to initiate our own bill for lay participation. So I'm going to echo what Valerie just proposed to establish maybe a worldwide collaborative research network on this subject, because I believe despite the trial is observed as vanished in the United States, but I believe that is what really is going on if you look at the bigger pictures in the world. And with regard to Neil, I just want to say, actually, we do have plea bargaining, and we do have the evidentiary rule, and the defendant's attorney got an opportunity to cross-examine the witness in Taiwan, and that happened just maybe 10 years ago. We understood a quite comprehensive judicial reform, both in the civil justice system and in the criminal justice system. But what happened is, after 10 years of reform, we noticed very little was actually improved. If you just reform the procedural rules, the experience in Taiwan informed us what you can achieve is really not that much. And a national survey I just completed last year shows about only 50% of the general public believe our judicial system is just. And that kind of approval rate make the professional judges quite embarrassing. What was going on? They think they are elites, very smart, well-trained, with extensive knowledge. But how come the public do not trust them? That is how we got into, we probably should start something more comprehensive or fundamental. And to introduce lay participation, from my perspective, is just a way for the judicial system to improve the legitimacy of their decision-making process and the support from the general public. But Valeria Hans was in Taiwan in year 2008. I remember I brought her and a group of foreign scholars to our Supreme Court to meet with our Chief Justice. And Valeria has a short conversation with our Chief Justice at that time about his opinion of introducing lay participation in Taiwan. And his response was quite negative. But after 2 years, the Chief Justice was forced to resign because there is a strong public dissatisfaction with the performance of our judicial system. And our new Chief Justice, his first public announcement was to introduce lay participation. So we start from ground zero just last year, and this year we have 2 bills pending in our Congress to be debated about which form of lay participation we should introduce. And one official proposal was just described by Valeria, that they just want to allow the citizen to observe instead of making the actual decision. And the opponent bill, I want the citizens to have a real decision power in that process. I cannot predict what will happen, but we will soon find out at the end of this year. So, thank you.
I just wanted to touch on some of what Neil had to say about Canada, because we face a couple interesting challenges given that the challenge for cause is not a given. So for example, if you want to have a voir dire where you ask about potential bias against the defendant based on race, for example, you need to justify that by showing a realistic potential for partiality. And so going back to what we talked about yesterday with the difference between system and estimated variables, for us it's very important to investigate the influence of those estimated variables, because that's how we make the case for allowing these challenges for cause. And so, for example, in R.V. Williams, they did cite some of Neil's work talking about the influence of prejudice against minority races, and so now it's a bit easier for us to get that kind of challenge allowed. And so it's really important for us to continue these investigations. One other thing I wanted to say about lay participation is in Saskatchewan, at least, where I'm from, they've introduced sentencing circles in certain cases involving Aboriginal Canadian defendants, and it's a lay participation system in the sense that the victim takes part, elders from the community take part, other community members take part in deciding what the appropriate restorative justice kind of remedy is for the defendant in that particular case. So Canada is doing quite a few interesting things in that regard as well.
I had a question for Jay. There was a slide about appeal rates, and the appeal rate for the prosecution was over 50%. And was this for, can the prosecution appeal acquittal and sentence length in Korea? Yes. And so, if you have information on the cases that are not appealed and the cases that are appealed, this would be a very interesting study to see what happens on appeal, and whether the prosecution just routinely appeals everything they don't like, or is more selective than the defense, because the argument in most countries, in the high courts, the prosecution almost always, the government almost always does better on appeal than the defendant. And the argument the government makes is, we are much smarter and more clever about which cases to appeal and more selective. And so you may have data that could shed light on this. You need the data on the cases not appealed, and you may have them. It would be very interesting to study it.
I wanted to offer another possible interpretation for the high rate of judge-jury agreement in Korea. I haven't looked at the American studies of judge-jury agreement for a while, but my recollection is that the way it's measured is typically by asking the judge a subjective question after the jury renders its verdict. What would your verdict have been? Do you agree with the jury's verdict? Do you disagree? Yes, no. I can easily imagine that in many of these cases, the judge would say, my verdict would have been different, but I wouldn't necessarily change the jury's verdict. I think the jury's verdict is reasonable, so even though I disagree with it, I would not reverse it. Whereas what you see in Korea, at least with the data that you have, you're looking at situations where the judge actively did reverse the jury verdict. So one possibility seems like the Korean judges are exercising judicial restraint, where in many cases perhaps they disagree, but they're not reversing the verdict, and that could push up the agreement rate.
Swan songs are not only beautiful, but long-winded, for example. And let me make a couple of general comments today, this morning's session brought to mind. A lot of us have spent a lot of our time focusing on the flaws of the jury system as it's practiced in this country. And I'm struck this morning, again, with many virtues of this system, and two of them particularly come to mind. One, that people all over the world are experimenting and seeing as a reform in progress in their country if they can incorporate some of these elements into their system. And the second thing really caught my attention, and that was that Neil told us about these Moldovan judges who said, if you have this jury system, these ethnic separations and so forth will cause it to fail. Jay told us about some data. I've got a Korean student who says, things like hometown region come from a very important Korea. And there are prejudices and stereotypes and so forth. And I was incredibly struck by the fact that the majority of the general citizens thought that these things would persist, but the people who'd been in the jury, very, very few of them thought that they would persist. And I guess one of the other virtues of this system is that interaction, contact, dialogue is fundamental to democracy, and one of the things we like about the jury system is you get a chance to confront these differences. The second thing I thought that comes to mind here is that a lot of the early research 40 years ago when I started was very descriptive. How do juries work? And then I think it also became saying what are the problems that fail assumptions of the system. And a lot of the work has been to try to then reform the system with a lowercase r, tinker with it, and change this and change that. And even when I made my presentation, I said, well, choose problems where there's a controversy, you can do something about it, don't tilt the windmills. But things we heard about this morning suggest that another good piece of advice is not only look at what can be done, but choose problems that deserve to be done. Tilted some windmills. Think about changes that look impossible. I imagine in some of these cultures it looked impossible that some of the changes that have come to pass would come to pass, but it took time and energy and hard work and data to bring about change. And the same, I suspect, is possible here if you're willing to invest in those kinds of problems. So we've heard about, should we have grand juries for civil cases? That's not common, but that can be studied. My own personal capital R reform thing is maybe we should ask whether peremptory challenges should continue. Long tradition, you can make arguments for it, you can make wonderful empirical counter-arguments for that. So I won't be with you, as Martin Luther King said, but I can see research on juries that will take on these hopeless problems, hopeless challenges, and I hope we can see that.
One of the reasons that I was really so pleased to do a global juries panel at the same time as panels with other specific topics is that I thought there was a lot of possible cross-fertilization. And actually, I have a question for William first, because when I listened to your presentation yesterday, it struck me that there were some implications for how the kind of work you were talking about might give us insights into some of these novel forms, to me, novel forms of lay participation. For example, the lay observer system, when at first blush, looks like a truly hopeless system. And yet, in terms of an effective lay voice, right? Here you're having people sit next to a professional judge, you're not giving them any votes. I mean, if I'm reading your work correctly, you might say, well, no, it makes a difference who is sitting next to you, even if you're a professional judge and you have lay people sitting next to you, you might be inclined somewhat differently.
perspective. And this would suggest not at all. And that very, very subtle changes can affect the kind of decisions they make, whether they're expert or non-expert. I would think the psychology suggests that's probably true. So yes, I think the process level professionals have I'd say something about the very nature of interaction and it reinforce, I think, the notion of the importance of lay people, even if it doesn't. I mean, the statistics are rather sad in terms of the layperson's influence on the decision, but small conversational bits can make a lot of difference.
So the training is from Brian, from his earlier remark, and I think you may be right, and I think we have some data that actually might help you look at that in terms of agreement rates, because in the old Calvin and Zeisel study, they asked a question, at least for part of them, about whether it was a decision the judge could also come to. And so you would expect those to be precisely the cases of, quote, disagreement that wouldn't have resulted in your system in a disagreement expressed because it was a case a judge could also come to. So I think it would be really interesting to look at it that way. I think there's also something else, and that is the higher rate of conviction, which makes the chance agreement higher as an initial matter. So that also would affect things. I think these are wonderful. There's so many questions that are looking here. The conference in Syracuse has spawned all kinds of things that are actually being enacted all over the world, which is very exciting. I just want to add a couple of variables. One that I think doesn't make sense, and one that I think that does. As I was initially listening until Sonia talked, I thought, oh, well, one measure people could look at across countries would be the questions the lay people ask in the course of the hearings, because, you know, that would be a good measure of the extent to which they're actually participating. Maybe they're not, maybe they're like Clarence Thomas, influential behind the scenes, but not up front. So maybe that's not a good measure. One thing that I would love to see looked at across culturally is the question of single participation experiences versus continued participation experiences. Because in the American system, we have a bunch of studies that looked at repeat performance over time. We didn't find too much. But for the most part, now that we're at 1 day, 1 trial, people do 1 jury service and then they kind of leave. But many of the systems, like in England, where lay judges have participated for years, are really continued multiple experience kinds of occasions. And I know some of the new systems are single experiences, but the German system is also multiple experience. And I don't know whether you settle in or whether you get empowered and you have more influence. And I predictions could go either way. It would be interesting to know. But great.
This is just a comment. As I told you, I'm writing a book, a sociological approach to the popular jury. And I see actually a trend worldwide in terms of the ways in which how the jury is now being embraced as the national democracy. That's one of the phrase being used. When you look at the transition from autocratic society to a more, say, democratic society, there is a fourth wave. I'm looking at the worldwide wave of the jury expansion, starting from the 500 years ago. And so we actually facing a fourth wave of this global expansion of this lay participation system throughout the regions. But they always have the one characteristic, that is, like I said, autocracy to democracy. And the French revolutions ignited the establishment of jury system throughout Europe until the totalitarianism being imposed, like Mussolini, Nazis, and Spain, and Franco's, and so on. And like in the case of Japan, Japan used to be controlled by the Liberal Democratic Party, but they lost control in the 1990s. That's when there was a discussion about lay participation. Same as in Korea until 1987, 88, there was military government, and it was defeated. And again, there was discussion of introduction of lay participation. Same as Taiwan too, very autocracy. And now it's a way of trying to democratize its social system, and lay participation has been suggested. And in these moments, what is really unique, especially last wave, is that what Richard Lepper had said. He said, all those people in those countries who started to initiate the discussions of lay participation are the people who actually studied in the United States. And Lepper had actually listed a group of students who actually took his class, for example, in Michigan. And those are the people who actually studied, for example, in Japan, the importance of lay participation and so on. And so also visiting scholars from other countries, they go back and they talk about it and create a space for the discussion. So it's very important that American scholars continue to do the research on this particular topic. This is very important. And like one of the reasons, like I said, Steve talked about the mean and the research international comparison between Korea and the United States. And she also used the methodological approach, covariance structure analysis. And those methods are actually being taught here too. Not only just particular approaches used for the jury, but methods are also being used by the international scholars. So I think it's very important to keep this tradition of the research the agendas. Because I can tell you this, the U.S. may be leaning more toward autocracy or a very rigid system, but it's going to bounce back. It's always there will be a tremendous discussions about lay participation. I see coming later.
We can continue to talk about this panel if we wanted to open it up to discussion about anything else in the conference as well. If there's anybody who has any remaining comments they want to make. Or retired. That has it.
One thing, so juries spreading around the world or lay participation, it seems to be almost completely limited to criminal cases. And whatever the reasons that motivate countries to have lay participation, if the norm is, well, it's a control on the government or the bureaucracy of professional judges, I'm not sure why those justifications don't carry over to civil. Whether it's the government controlling things or the large corporations controlling things, who in turn control governments in many places. It's curious that it's only criminal. And I think if you believe in the reasons for having juries, they may also apply to civil. So spreading that may be hopeless.
I was really curious if she wants to say.
I was trying to be subtle. Somebody mentioned, Valerie mentioned yesterday, this conference
That's going to be streaming video, and I was not going to mention it, but it occurred to me after we talked yesterday that this conversation among academics is great for research ideas, and there have been just a whole, you probably got too many and you don't have any time for any more. But this different conversation that we're going to have next week between some academics and lawyers and judges and jurors and a couple of jury consultants may also be a source of research ideas. So it is going to be a streaming video, and it should be up Monday, and so I put the website up here for you.
Oh, great. Anything else want to share anything before we? Okay, nobody else is last call for comments. All right.
I have one.
Brad.
I'm just kind of wondering what's next. I mean, this was a nice intellectual exercise. We had a lot of good discussion, but I mean, what's the next step in terms of product? I mean, it seems that there might be an international audience for a white paper on what we know about the jury system, or I mean, are we looking?
Well, there's hopefully a book. I mean, that's a longer product than a white paper, but certainly for the panelists who all spoke have agreed to contribute chapters to a book, and the proposal's going in as soon as I have a nap. So there's that, but you have some other idea for?
I just think in terms of looking at the eyewitness literature and what they've done, I think the currency of that is the white paper, and it gets cited a lot, and it's concise, and again, I don't want to sound pretentious, like we have all this information disseminate to other countries that are entertaining the jury system, but I think we do in some ways. So I was just kind of thinking about, as things were wrapping up, what's the next step, and wanted to throw that out.
I think for a white paper, I think we have to almost divide. There's so much literature on so many things that you have to divvy it up in terms of specific questions. I know there is, in terms of white papers being kicked around, there's been some discussion of one on pretrial publicity and effectiveness or lack of effectiveness of remedies for that problem. And I think we'd probably get the same type of punch you would get from that we got from an eyewitness paper. You might have to divide up the area a little bit. But if that's what you're interested in, Mark Costanzo right now, who's the chairperson of the Scientific Review Committee at APLS, and I have urged certainly that I would love to see white papers because I want to publish them on law and human behavior because they're great for urban impact factor, among other things. So if you have ideas for that in this area, I was just talking with Mark Costanzo and seeing if we can get something together on an area that would be dealt to the executive committee because they have to approve it too. But that's what something we do. Okay, that last call. Just a couple housekeeping issues before we end. There is lunch outside, so for those of you who don't have to leave immediately. For those of you who use slides in your presentation, if you can make sure the updated version is on the website. They're going to be, when they edit the talks together for future posting on the web, on iTunes U, they're going to be editing the slides in the talk to make sure that it's all legible. So make sure you have the latest copy of your slides, and I'll send you an email reminder to just kind of put that on the agenda. Your reimbursement forms, if you could turn them in sooner rather than later so that it's not dragging out for me forever, that would be fantastic. I want to make sure we thank a lot of people. I want to thank Chris Meisner, if he's watching ever, because without him I wouldn't have known this money was available, and we wouldn't be here. Certainly National Science Foundation for funding us to be here today, and we also got some financial contributions from Law and Human Behavior, so we should thank them as well. I got a lot of support from my department, especially my department chair, Tom Kaczorski, who was here yesterday, in terms of lending me the administrator, supplies, and all that, so they were very helpful. I couldn't have done that website, so our IT people here were great, audiovisual folks for being here, and live streaming. We think some people got audio, some people didn't. But apparently we have all the audio, so it will go on to those podcasts so that if you want to use these resources for your classes, I will be sending out a notice as soon as they pull all that together so that you have that resource for you. I want to thank my grad students, I think almost still all here, for running around behind the scenes and doing stuff, and for giving me 24 hours last week when I thought I was going to kill them because they weren't leaving me alone, and I really needed some time to write my comments. So I've never asked my graduate students to leave me alone before, and that was the first, and they were great about it. The advisory board, Brian Cutler, Edie Green, Laura Levitt, and Val Hans, who gave me great ideas about who to bring in. And, mostly thank you guys. I don't know. I've never been to a conference where there was a whole day and a half of talks where I never wanted to check my email or when I make a phone call or, do anything else other than be here and listen to you all. So it was a great experience. A bunch of people said they didn't know why they were invited. And that seems kind of crazy to me after listening to the talks, because you all had a purpose, you all met your purpose, and I'm just very grateful for that, and I'm especially grateful for Nora that we got a swan song, because that's a great honor for all of us, I think. And the goal here was to set forth a research agenda for people. And I think we did that, and there's a lot of questions, and I look forward to seeing those questions answered and submitted to non-human behavior, please. So other than that, thank you all, and have lunch, and safe travels home.